Donald Trump's criminal trial is underway in New York, but a key case involving the former president is due before the U.S. Supreme Court on Thursday. At issue, Trump's claim of absolute immunity from criminal prosecution. Now, the fate of his federal criminal trial for allegedly attempting to overturn the results of the 2020 election hinges on the court's ruling. Of course, all of this is happening against the backdrop of the 2024 campaign with Donald Trump as the presumptive Republican nominee. For more, let's bring in our correspondent in Washington, Fraser Jackson. Fraser, with 4 criminal cases in process, Trump's court calendar is pretty full, but this case coming before the Supreme Court tomorrow is really important, isn't it?
It's definitely important, Monty, and it's important not just for Donald Trump's legal future, but also the future of the United States. And that is something that various members of the bench behind me in the Supreme Court are worried about, especially the conservative justices, including Brett Kavanaugh. They are worried about whether a ruling one way or another could rein in the powers of any future president. And one of the reasons for that is because when the Supreme Court surprised everybody by deciding to take this up just 2 months ago, even though most people agreed that the decision that had been found by the appeals court here in DC was lengthy and also basically could just be rubber stamped by the Supreme Court. They then tweaked the Supreme Court, the arguments that they would hear on Thursday to include, quote, whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. Now, the 3 court justices that Donald Trump put on the bench behind me are all obviously more conservative on their political leanings, but it must be said they haven't been entirely in Donald Trump's corner so far in the various legal challenges that he's met here in the Supreme Court. So all eyes will be here tomorrow morning at 10 o'clock to see what will happen as those 2 hours of oral arguments get underway.
Well, so Fraser, we know that Donald Trump's playbook has been to, delay every case he's been involved with. So when we're talking about the federal case against Trump related to January 6th, how likely is it to go to trial before the election in November?
Well, that all really depends on what's going to happen here on Thursday, because the ruling that the Supreme Court brings down, which could be any time between the end of the oral arguments to the end of the term, which is the end of June, really are likely to shape things in the future. So far, there's not much precedent for the Supreme Court to go on. This really is uncharted legal territory for the Supreme Court. The closest thing that most people are drawing comparisons to are the Nixon cases that we saw in the early 70s that judged that a president could not be found responsible, at least not civically, for anything that happened during their time in office. However, that didn't go so far as to cover any criminal actions. So that really is now what has been decided upon. So far, the Supreme Court doesn't have anything really to go on. They're relying on some of the decisions that the lower courts, the circuit courts, also found as well. But also, Donald Trump has a very busy calendar coming up as well. And he also will be trying to the Jack Smith, that is, the counsel here, will be trying to squeeze in one of those trials before that November election, because it is Donald Trump's legal strategy to delay until past that vote. So he hopes that he'll be in office and will be able to make these cases go away. But of course, we've got the documents case in Mar-a-Lago to come. That is scheduled for May, but is likely going to be delayed. The election subversion case in Georgia is currently slated for August. And of course, the trial currently going on in New York as well. So it is a bit of a time crunch as we get that month of November slowly encroaching as well. But really, it is going to come down to the Supreme Court. Whatever they decide is going to be the vital factor here. They could decide that more evidence needs to be considered here, whether the scope needs to be broadened out a bit. If that is the case, that will mean that this will go back down to the trial judge, and then they therefore will have to decide whether they need more evidence to be entered into a discovery period, which then could really push this beyond that November scope. So it is all very vital for Donald Trump, especially as most people see this as the most important one.
A lot to keep track of. Okay, our correspondent in Washington, Fraser Jackson, there at the Supreme Court for us. Fraser, always good to see you. Thanks for joining us. For more on this story, let's bring in Carl Tobias, a law professor at the University of Richmond. Thanks so much for being with us here on France 24. So help us understand what the law of the land is at the moment. Now, is it that a president is immune from criminal prosecution while in office, and that when he's out of office, he's back to being a citizen who can be prosecuted? And if so, where did that understanding come from?
Well, not necessarily. We really don't know. This is, as your interlocutor said, uncharted territory. There never has been a former president who has been in this situation. So the courts have not really passed on that. And that's why it's intriguing. And the Supreme Court said that there are really two pieces, as your interlocutor just said. One is the extent to which there is immunity. Is it absolute, or is it qualified in some way? And if so, how? And then secondly, whether Mr. Trump was acting in his official capacity, and if so, to what extent, or as a private citizen. And so pursuing his own private interest. And so I think it's exactly right to say that it is going to be very difficult for Judge Chutkan, who has the case back in the district court, to begin, much less finish, a trial before the elections. And as you suggested, President Trump, former President Trump, is most interested in timing and delay. And it will be difficult to have that case start because it's likely that the Supreme Court tomorrow could well reflect in its arguments the idea that these are open questions and that they will need to be resolved by the lower court judge in the district court.
Let's talk more about that. You know, Trump's attorneys have gone as far as to argue that when the president is in office, he or she has the power to even order the assassination of a political rival and could not be criminally prosecuted unless first being impeached by Congress. You know, this is a conservative court. 3 of the justices were appointed by Trump. But how do you think that this really quite audacious argument will sit with the justices?
Not terribly well. It didn't at the time with the D.C. Circuit judges who actually asked that very question. The Republican appointee, Judge Henderson, is the one who raised that question that you just asked. And I think that may have led to the unanimous decision because it was so audacious. So we'll just have to see. But I think part of the problem, or part of the issue, really revolves around concern on the part of the justices about the presidency and how much leeway and flexibility a president needs to have in order to do what's necessary in this high office, and often without full information and sometimes on the spur of the moment, and sometimes in the national defense and saving the country. And so I think there may be a need for some flexibility in the minds of some of the justices, that the president needs to have more power than maybe some other officials.
Just to pick up on that, when you look at what the founders of the country intended, what did they mean for a president, you know, to be above the law? Was it their vision of presidential power? And how might that all, you know, factor into this decision tomorrow?
Well, I think that they believed it would be limited because of the way they created the government, that there would be checks and balances, and you would have the legislators in Congress, the Senate and the House, and you would also have executive officials appointed by the president, but there would be checks. And then, of course, the judiciary would have checks on the other 2 branches. And so that was the beauty of the government that was established in 1789, basically. And so The question, one of the big questions, is how you satisfy that in a modern world which is full of dangers, and how much presidents need by way of flexibility.
Okay, we'll have to leave it there. Carl Tobias, law professor at the University of Richmond, thanks so much for joining us for this special segment, Apropos, and for joining us here on France 24. We appreciate it.
Thank you.